So he says right here, the framework, the historical background of different land classifications and conveyances in them, the types of records, recordation systems, maps, description, fundamentals, including words and phrases, evaluation of controls, applicability of codes, areas, curves, ramifications of boundaries, analysis and interpretation of descriptions, monuments, streets, and occupation versus title have all been discussed as a background preliminary to the study of creating and writing legal descriptions. It has been said that descriptions which must leave interpretation to construction leaves some uncertainty. Rules of construction are needed and used when the wording is not clearly stated. All rules relating to the comparative dignity of calls are designed to aid in determining which call or calls of a survey were made by mistake. A good draftsman should avoid placing his client in the position of a supplicant for mercy. Before starting to write a description, review the do's and don'ts, which we did last time. This will sharpen your memory concerning some of the mechanics involved in such a project. So the first thing, he gets into the parts of a description. So those that have read it, those that have taught this, what are parts of a description? What does every description need to have in it?
Caption.
You got the caption,
Body.
body,
Augmenting and augmenting clauses.
and augmenting clauses. Okay.
Qualifying clauses.
Qualifying clauses. Yeah. Anything else we need to have in there? We covered it in those three.
I tend to have students break out and have a summation at the end also. That's where you put in the call for area and any other ancillary information for the description.
Okay. I like it. The second paragraph of parts, he says, your slogan should be concise clarity without ambiguity. Do not use time or space for superfluous words, but on the other hand, do not omit words or phrases that are necessary. Ask yourself the question, will the omission of these words change the meaning, or will the use of these additional words add to or subtract from the actual meaning of the whole phrase? And here's the weird part, the balance with descriptions is we kind of write them a little old timey, the lenses and the situates in, and you know, I've seen all sorts of phrases that are thrown in there. And I think it leads some surveyors to want to add and be really flowery and all this additional language. It doesn't always help. Jumping into forms, he says there are several fundamental formats for describing a piece of land. They're a reference to the single parcel outlined on a map with a unique identifier assigned to it. A part of a large parcel, which can be described by either the long form known as the meets and bounds, or the short form expresses the south so many feet of something. Boundary deeds of record, the strip of land taken out of one or more parcels and described either singly or as one whole piece or in multiple by separate parcels. And section land or subdivisions thereof described under government nomenclature, your aliquot part description. And he says the last two will be discussed in subsequent chapters. So jumping in here, some of the forms we've got: lot or parcel number or letter, block number, letter, tract, city, county, state, map record, public office. For the first format, one of its applications to the facts would be as follows. So this is, a lot of this can be some reading because it's just really easy to read kind of how he's jumping together. Lot 9, Block D of the Higginsville tract in the city of Downsdale, county of Summertown, state of South Dakota, as per map in book 17, page 32 of maps in the office of the county recorder of said county. So this is what I want to get some group discussion. Those that are dealing with lots or tracts like this, kind of get a consensus of how do you guys write that and reference that. Is there an order you put that in, or certain rules that you follow as you guys try and describe a track like this?
What he has right there is exactly what I would be putting down.
Yeah, I'd second that. I was always taught that basically it's like writing an address on an envelope. You start out with the specific parcel, the person, and then you work your way down to the city, county, state. And then here they've got, this is kind of a combination of really once you got to that down to the state, that's typically where the caption would end. And then you've got the specifics in the body, which is the more particular description, which is the book 17, page 32 reference. You could look at it that way, but yeah, this is kind of a caption only type of a description.
Yeah, it tends to be similar to like you do a adequate part description. You start with the smallest part and work your way to the largest part where it's all type of stuff. So it's consistent with respect to that.
To get really nitty gritty detail, I've seen a lot of different ways of doing it. In Utah, we generally have an entry number. In older deeds, we have a book and page. As we've got more electronic, it's all just entry number. But so the recorded in book 17, page 32 of maps. Is there a benefit to writing out all that information, entry number, book and page? Or is that something unique to Utah? How detailed do we get, or redundant do we get with some of that information?
Typically in Wisconsin, what we do is we break that description that you see there into the caption and in particular, where you would say a parcel of land located in whatever the county is, and then lot, and then in a particular description, lot of subdivision of county. Because you have to have a unique subdivision name in Wisconsin for every subdivision. So once you got it down to the county level, then you don't have to give the book and page, although you can. Some people do that, but just identifying it by the subdivision gives you sufficient information to locate that parcel, or to locate the map parcel.
Yep. And that's generally how I would write something like this, giving the kind of the government entities, maybe section, township, range, city, county, state. And then, but in this case, my description would be, separate paragraph, the body of it, all of lot 9, block D, Higginsville tract, city of Downsdale, right? But everything else, that's kind of the header and the body, or the caption in the body there is the way I would generally write something like that. So I give some other examples here. Those portions of lot 6, 7, 8, and 9 in block 3 as described as follows, or those portions of sections 10, 11, and 12 in township 3 south, range 6 west described as follows. And then you can give those descriptions down there. He says, let's see if I can get the highlighter here. In each case, the meets and bounds will be added. That's not highlighting for me for some reason. Oh, there we go. Another suggestion for the first part of the second format would be that portion of farm lot 114 in Tom's Vineyard tract in the County of Wildlife, State of Wyoming, as per map recorded in book 76, page 28 of maps in the county in the office of the county recorder of said county, described as follows. In describing a part of the above could be as follows: the south or north 250 feet of farm lot 114 in Tom's Vineyard, and he goes on there, or the west 196 feet. So just some different examples of how to write kind of the same type of description there. He says on the next page, also, instead of continuing courses following the word thence, a program of numbered courses may be used thusly. This gets into our argument of kind of a paragraph form or a list or column form. which I prefer that list or column form. So if I'm following along a boundary of something or continuing along something that's sequential, I will generally use this type of format where I will I will say, that's along, this boundary, this road, or this subdivision, the following, 5 courses and distances, 1, 2, 3, 4, 5. And we're omitting the events and just kind of saying, hey, here's a group of calls that all go together. What do you guys think about that? How do you guys approach kind of simultaneous calls that would be, tied along a boundary and doing a list like that?
The advantage of doing sequential calls in a format like this is it's harder, not impossible, but harder to drop a course. If you're writing it in narrative form in a dense paragraph and stuff, it's very easy to drop a course, leave one out, and cause problems later on. Plus, written in this form, it's easier to interpret because you can see what the individual courses are instead of going through and trying to figure out where does one course begin, another one end in a big, long narrative.
I agree. I agree. Any other thoughts on that? We'll jump over to the next section here. He says the last 2 forms above illustrate the free line description. That is, aside from the lot boundary and the other lot lines are free from any joinder parties. The opposite form, using only boundary references, would be expressed thusly, and he brings that up kind of the following pages here. That portion of farm lot 96 of Tom Vineyard Tract, etc. Boundaries follows on the west and north by the land, and I've seen this a lot more working in colonial states. When I did stuff in Ohio and West Virginia, we saw descriptions. Bounded on the west and north by land of Raymond Blues is described in this deed. On the north and east by the land of Tom Gray is described in this deed. He says, note that it is unnecessary to state on the south by the south line of lot or on the south by the north line of Concord Street. These are facts shown on the map described in the caption, which therefore includes all the facts shown thereon. Have you guys ever experienced, I'm sure our East Coast guys have more, but experienced those type of deeds?
Yeah, I have once or don't, but only a few times out here in California. But it only takes one time to have to go through one of those, and you say, never again.
Never again.
I'll find another way to do it. Just setting up all those parts, all those pieces of it on a bounds that's a lot of work.
It is. Oh, go ahead.
I'm sorry, I was going to say I'm in Cincinnati, Ohio, and I see that a lot.
Yeah, that's where Ohio, I saw quite a bit of that. And it's funny, you think you're ready to pull those deeds, and you go pull those deeds, and they're bound by more property calls of the same. And it's just this ever evolving bubble that you just keep getting bigger and bigger and chasing it. Okay. Although the above type of description using boundary deeds of record is perfectly good for title, it is difficult not only for the surveyor in the field, but also for the draftsman to use without copies of all reference materials. It is much more desirable to describe the lines as given in the deeds and then correlate them with the deed references. There is still another type of short form description that is used in lieu of meets and bounds. This can be adapted and used with any of the above cited caption forms, thus the north 40 feet of lot 4, etc. And he's saying this here, but he's actually given a lot of caution to using these types of descriptions in previous chapters, right? He's illustrated challenges that may happen of what is the actual north 40 of that if it's an irregular shaped tractor or anything like that. And then he gets into exceptions. A different type of application of the short form of description is by the use of exceptions. This is often simpler and safer than by meets and bounds. The entire caption is used as before, and then an exception follows it, such as except the south 30 feet thereof. And I've just been doing a whole bunch of those lately where the DOT has taken parcels of land and accepted out an easement for themselves, the north 10 feet, the north 20 feet. And you still have to draft up the whole parcel and you can block out that north 10 feet for the easement. But dealing a lot with those type of descriptions right now.
Yeah, but you can get in trouble with some of those really quickly, depending on what the shape of the parcel is. Because when you've got the south, except the south 30 feet thereof, how south does that line have to be, the southern boundary, versus, southerly and that type of thing? Again, those interpretive issues. And what if it takes turns that go north for a bit and then go east for, it can get problematic.
Absolutely. Yeah, and it's interesting that he doesn't point that out very clearly. As much time as he spent explaining exactly what you just said, Jerry.
Yeah.
Now he's kind of carte blanche saying, "Yeah, go do it."
Yeah, where it comes in real handy is if somebody's like taking a lot and he's dividing it into two and he's selling off the east 100 feet and the west 100 feet, inevitably going to wind up with a gap or overlap situation. If we sell off the east 100 feet and then lot 7 accept the east 100 feet, then that exception takes care of any excess or deficiency in that parcel. So that's where it's good because you don't have calls from both directions that can cause that conflict later on.
Absolutely. Okay, jumping over to sufficiency. The value of the deed description depends on it being sufficient and unambiguous. Even a county omitted from a description has been held to render a trust deed and the subsequent trustee sale void. When performance of a contract depends on the description, it must contain all the necessary requisites so that parole evidence is not needed in order to correctly identify the property. Otherwise, the contract may be void for lack of being able to properly locate the land. So I figure we'll spend a moment. We've talked about this quite a bit, but those experienced surveyors on here, how do you ensure that your description is sufficient, that it passed muster? Do you have a checklist you use, a QC process? Give you guys a second to kind of throw out what you do.
I make my wife and my kids read them back to me. Just like Trent said last week, he uses all of his people to do it. When you're in a small shop, like I had, I use my party chief, use one of my other employees to read it back, go through it. My wife and kids hated me for bringing home some lengthy legals to go through, and I'm sitting there, they're going through all the traverse closures for it, and I'm going through the sketch and the legal reading back and forth. Yeah, you got to have extra eyes. It cannot hurt to have more eyes looking at to find something. Someone will find something different every time.
I think that's a good way of doing it too, is someone that's not necessarily in it. An experienced surveyor sometimes can read over ambiguities or deficiencies because your mind knows how to fill in the gaps. But having someone that is unfamiliar with the project or even unfamiliar with descriptions, often if it's one I'm having trouble with or I've reworked a few times, and I'll have an engineer that doesn't do deeds a whole lot go through and try and punch the deed and recreate it because they're going to catch the stuff that the layman wouldn't understand as well. Anyone else want to throw some ideas out there? How do you make sure that your deed is sufficient? Your description is sufficient. Anyone have any checklist items you guys make sure, like I've got this, this, and this? I think that might be a fun thing to try and come up with as a checklist. I'm a checklist person.
Does anyone here use description writing software? or have description writing software built into theirs and generate it that way. I've seen some interesting things come out of those.
It's almost like using Chat GPT to write your legal for you.
Well, I've started to see things like that that are kind of
Yeah.
questionable too.
Wow.
Well, I like using the software just simply to be able to gather all the course data so that I don't omit one by accident. And then you go through and you actually turn it into a legal description. So it's not just a bearing distance, bearing distance, bearing distance to the point of beginning. You know, I can pull the line work that I've got in my CAD that I know is a closed figure, that it's the final result, and I can run the software that'll extract all the bearings and distances without error. I don't have to retype it all or anything like that, because the computer can extract that data a lot better than I can retype it, especially with that if it's a number of courses and stuff. So yeah, I use my software all the time. I export the DWG file into a DXF and then pull it into I can't remember the name of the software now, but it's actually quite good. It does a lot of stuff. It'll do strip descriptions. It'll do full parcel closures and all that stuff. It gives you all the data, and I can compare that data with closure data with the closure stuff that I'm getting in my CAD software. So I've got to cross check that way too. I'll have to look and see what it is that I use. Well, it's called ProCogo. It's a fairly inexpensive software that it has embedded in it the legal writer software, between the combination of it'll import the DXF file and then use legal writer to prepare the description.
And that
Or
gives you
it's
the body of
expanded.
that gives you the body of the legal description, and then you just got to rewrite it so it's in the form that you want, and
Yes.
add your caption and add anything else at the end, and then you're good to go.
Yeah, and the nicest the way it handles curves. It's entirely flexible. You can program it to do your curve routines however you like them, but it'll extract your radius, your delta, right or left, or whatever concavity or whatever you want to use for how you prefer to write those descriptions. But it'll extract all that curve data, which is a bunch of stuff to have to build in every legal description. Saves a lot of time.
I have the same approach. So can you guys, did that share properly? You can see this
Yes.
is
Yeah.
this is Legal Aid. It's one of the programs out there. And I do the same thing. I'll use it for most every description, but particularly one that's got multiple calls. I will use this. It definitely has some things you've got to fix on there. In fact, like all your, I don't know how well you guys can see that, but your radius calls, it's 1240.00 feet dash foot radius. Like it just does that. Why or how to fix it, I don't know, but I know I've got to go through there. But for me, it's a great way of not transposing numbers when I'm writing it, right? It's just a safety factor for me. But I do go through, like John said, with a fine-tooth comb and make sure that I get all my calls in there. I've checked it, but whatever that line work is, that's going to pull in a correct, just mathematical boundary for that. And then I go through and do my checks. And then we've got that QC on the back end, having someone separately and independently checking it.
Yeah.
Great. Anyone use any like Civil 3D inherent stuff? It's got some programs in there, but I've never really gotten into them, but it's got some map check things. Anyone ever tried using those type of tools? Doesn't sound like it. Okay. Well, for beginnings here then, and this is where I'm curious how everyone does it. I've seen beginnings called in so many different ways. Commencing at a point to the true point of beginning, beginning at a point which is bearing a distance from a monument, and a dozen other ways. So before we kind of jump into some of this text, curious, regional preferences, personal preferences on how you tie it to a beginning.
It's totally up to you. What do you want to use? Do you want to use points of beginning or points of commencement? I know my dad and I would go back and forth whether to use point of beginning, true point of beginning, or point of commencement. The county of Orange, where I work now, they only use point of commencement to a true point of beginning. They're all the different types are out there. Whatever you're most comfortable with.
Any other thoughts? Any hill that anyone wants to die on? I was expecting more of a fight today, guys. I'm a little disappointed. Let's someone disagree to disagree here.
The only thing explicit that it says in Wisconsin Administrative Code, minimum standards is that any meets and bounds description has to commence at an original federal corner, section corner, quarter corner, or at a corner of a previous survey tied to one of those. So that's your commencement point. And generally from there you go work your path to your point of beginning, which is the first point on your parcel that you're describing. Then you do your perimeter description and come back to the point of beginning. So traditionally here it's point of commencement, point of beginning. We don't get too much into this true point of beginning versus point of beginning and all that kind of stuff. If it's not true, then it must be false. If it's false, then why do you want to use it?
I like it. Anyone else?
I have a question.
Yeah, go for it.
Okay, so I'm not a surveyor, but you did mention something about contracts. If the deeds didn't have a description that was accurate at the time of a sale or a transfer, and these things can be void. Is that what you were saying? That if the descriptions weren't accurately recorded at one point, and then they sold, it becomes a problem later, so you could void things?
It's not a question of accuracy, it's a question of locatability.
What do you mean by locatability?
Be able to locate it on the ground. That doesn't really have to do with accuracy. You can encroach upon a senior owner and you wouldn't have a very accurate description, but it would still be locatable. You just have to locate it with respect to the right.
So you have to have that all in descriptions when these things are performed, these transfers and contracts.
Yeah, so the example the book gave that we talked about was he referenced, and we could probably get back into his references in the book, but he was mentioned a deed that didn't have the county in it, right? And so if you were to go in a true sense try and retrace that deed and the county was critical to it, you couldn't place it somewhere in the state because it was missing the county.
I see. Okay.
Then it might be void because you don't know where it is. You don't have enough information to locate where in the ground it is. For example, if it said the northwest corner of beginning at the northwest corner of the Williams parcel and running thence, well, Williams is a common name. So which Williams parcel is it, right? And if you don't have some more qualifying information in there, then it might void the deed. It may void the deed because you don't know where that Williams point of beginning is, right? Which parcel it is. And so the courts would say, hey, there's not enough description here to pass it.
Thank you.
I was trying to pull that up real fast, but it didn't pop out. Sufficiency here is where it was. Too far down here, so beginnings. So Kyle just shared an image. Let me pull his up here. Can everyone see that one all right? Beginning at the northwest corner of the parcel described herein. A half-inch capped iron pipe from which the west quarter corner said section 34 bears 4 courses. Then from the point of beginning north, 760349 east, 220 feet. So he says, beginning from which something bears.
Yeah, that's definitely the norm here for legal descriptions in El Dorado County, California. They seem to like beginning and then giving you a record tie to, whether it's 5 different courses to something, so you could, hopefully work back to the point at the beginning. And then the other thing that I think is interesting is saying the beginning at the northwest corner of the parcel herein described. That's saying beginning right here where we're beginning is the beginning.
And we'll begin here and go. I like it.
Did that have a caption with it? Did it say this is a parcel, a part of such and such as parcel?
It does have a caption. The land here in, it's an unincorporated area of El Dorado County, state of California, described as follows: portion of the northwest quarter of section 34, township, blah, 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 described as
Okay,
follows.
so the question
There's
is
no
that-
parcel map.
okay, so it's a question of whether that point of beginning is actually the corner of that larger parcel. Yeah. This is, yeah, the one that he's got up there now, this is one that was recorded in Dane County about 15 years ago. And you talk about sufficiency of documentation. There was no address on this. We don't know where this house was. And so, I mean, this is, when you record a deed, at least in Wisconsin, ours is a passive deed recordation system in general. They only check to make sure that there's a description there. They don't check the sufficiency of the description and make sure that it makes sense. For one thing, they're not equipped to do that. So if they see this description on there, they'll go ahead and say, yeah, that's fine. There's a description there. Everything else is there. The grantor, grantees, and all that stuff's identified, stamp it, seal it. And generally, it's considered then a sufficient for a description. And courts generally hold that if a description is sufficient at time of conveyance, original conveyance, nothing can act to make that description invalid later on. So this becomes a challenge. This is one of the better ones. Yeah, and I'm sure you've all seen stuff like this where you kind of, the client hands you this is my property, say, just a second, I have to consult with somebody, and you walk around the other side of the truck and drop down to your knees and thank God, because you're gonna make a fortune off of this one.
Absolutely. Seen some good ones like that too. We could definitely share. Jumping back over to the book. So no consensus then on how we call out our point of beginnings, other than just to make sure it's clear and concise. He says, for meets and bounds descriptions, the competent and verifiable point must be either in existence or properly established in relation to an acceptable point or points for the beginning and control of the land described from it. The point may be represented by a post, a tree, an iron pipe, or a rod, an intersection of 2 streets, or the intersection of 2 lines having dissimilar qualifications, etc., but it must be clearly identified or its value will be lost. Has to be retraceable. Has to be a known, findable point so that you can retrace from there to get to your parcel. Again, in the layman's term, right? Describe it in such a way that someone with very minimal survey experience can look at it and walk the property, right? Even if they don't know what the northwest corner of section 34 is, that's pretty easy to figure out in a number of ways. And they can then walk west along the section line. They can walk west so many feet and figure out and kind of get where they are within any reasonable standard. And then add in enough qualifying clauses and precise calls that, a surveyor then could retrace it.
What about a description that's strictly given by coordinates? Because we've already seen those. Yeah,
that's a guy. I've got lots of problems with that. We've got a couple of cities here in Utah that require coordinates on plats.
Yeah,
they've got descriptions on them, but it's still, it does no one any good because people don't understand coordinates, right? They're so easy to screw up. And
but we've got a couple in particular, we got coordinates in decimal degrees of latitude and longitude. So that's even worse than having them on a state plane or a county coordinate system or something like that. Because you don't know where those came from or how accurate they are. And it's always the description goes, thence so many feet more or less, the GPS waypoint, and then they give coordinates in geodetic coordinates in decimal degrees, and then continuing from there. So that's all you've got to work with. That's a meets and bounds description.
yeah, I mean, besides educating, how do you combat that? That's, you know, and there's even professional surveyors or survey companies out there that are using things like coordinates, county coordinate records to reestablish section corners that, you know, the county themselves says are not, for that type of use, not accurate enough. And that's a tough one for sure.
Yeah, that's one of the reasons I retired.
Well, it's probably okay as long as you give all the datum information and where it came from. You got to put some clauses in there to cover your tail.
Yeah, none of that stuff's in these descriptions. I mean, the coordinates that's good enough, right?
Yeah. But exactly. Where'd they come from? And that's what Wattles says later in the chapter about coordinates. You know, well, where did they come from? How good are they? Who did them? You're opening up a can of worms.
And anyone that's probably qualified enough to get the full and actual calls of where did it come from, what is your datum, and all that stuff. Anyone that's smart enough to pull that stuff correctly out is probably smart enough to actually do a real description. There's a lot of that out there too, right? That just don't understand even how the equipment does it in the background. Okay, basis of bearings. Bearings being plural because it controls all the bearings, right? I've said that a few times here, haven't I? This is written with the first word spelled as either base or basis. Webster makes no difference between their meanings as related to our use and descriptions. Here's an interesting one. I've seen a few descriptions that actually do call out a basis of bearings in the description in various different locations of there. The general practice in Utah in writing deeds and then retracing deeds is, you know, you've got your old deeds that's north, south, east, and west, right? Beginning at a point which is north along the section line and east to the point of beginning, and then north, south, east, and west around the property. And it's generally understood if it says north or north along the section line, your basis of bearings is the section line, and whatever rotation to that deed, adjacent deeds, subsequent deeds, then goes along the section line. Pretty easy standard of practice to retrace in that sense. They're not specifically calling out a basis of bearings. How many of you guys do put a basis of bearings in? How many of you guys or your states or regions require some sort of basis of bearings call in your deeds?
Wisconsin, you have to reference your meets and bounds descriptions to a quarter line of a section. So you have to have two adjacent corners, either a section corner, a section corner, and a quarter corner, basically. But you do have to, you can assume the direction of it, but you have to have that line and what the monuments are at both ends of that line.
It's definitely becoming more common for people to request a basis of bearings added into a description. I see it more and more now.
County of Orange adds a basis of bearings on his legal descriptions. In prior practice, I never did.
And in this case, we're generally talking, this to clarify one thing, we're talking about a written description that might be a standalone description that goes to a deed or other things like that. But on a record of survey, for example, right? it's really common to see that basis of bearings called out graphically there, but there's this disconnection often between a record, a survey graphically describing something with a written description on it, or a written description that gets put into a deed or on a plat that gets separated off from the plat, or a number of things that has no basis of bearings tied to that written description. I would assume it's pretty common practice to have a basis bearings on a graphical record of survey or plat, right?
Yes.
Though I've dealt with one this week that didn't.
It's a requirement on our record of surveys. That basis of bearing statement is in there. And it's actually pretty debated between different parties as to what basis of bearings actually means. Like, some people think it's got to be between two found points. Some people think it can be any line at all, and that's a whole can of worms.
Yeah. Well, I showed a few weeks ago the survey that I was retracing, where it said point of beginning, or the basis of bearings was between a section line and a calculated intersection, centerline intersection, right? But no qualifying of where and how they calculated that intersection. It's not retraceable in that sense, right? Okay. Jerry threw up, let's share Jerry's description here. He threw one in the chat. It says no data was provided. Part of the southeast quarter, the southwest quarter, and the southwest quarter, the southeast quarter, section 30, 16 north to west, Monroe County, Wisconsin. More particularly described as follows: commencing at the southwest corner, the southeast quarter, the southwest quarter, that's easterly along the south line of the 40, 1,102 feet, more or less to GPS waypoint, latitude and longitude, which is the point of beginning. That's continuing easterly along the south line of said section 30, 1592 feet more or less to GPS waypoint this and this. That's northerly 487 feet. So there's that.
Yeah, it does after
towards
those
the top.
3 courses, then it goes back to the point at the beginning. And that's it. That's a description.
And that was on a deed, not a record surveyor had any other qualifying.
That's the deed. That's the document of conveyance between two parties. See, and then again, because it was recorded, that's sufficient. That description is considered sufficient. There's all sorts of questions about this. I always use it, like to use this for a discussion and deed interpretations and stuff, but it's happening. It's happening. Because it's not just surveyors that write descriptions.
Yeah.
If a surveyor wrote this description, he needs to have a range post shoved through his ears. Okay?
Tell us how you really feel.
I'm sorry, GPS staff. Okay. I'm dating myself.
Well, because it could be a landowner, right, splitting off his own property, which he has every right to do, but that makes it difficult.
It most certainly is somebody like that that's got a GPS app on their phone and they're just walking around and getting corners that way. But you know what? It's up to you and me to interpret what that is, to locate it on the ground.
Absolutely. And that makes it tough. But public outreach and education is critical, getting our word and our profession out there. That's a discussion for another time. Kyle threw here, getting at the GPS photo taken via Onyx, thence somewhere, and I know Utah and even California, some of the Western states have had lawsuits against some GIS sites that are purporting to be able to recreate and make descriptions or boundaries on their GIS maps. Onyx does not make a mistake. When the game warden gets you for shooting on someone else's land, we'll see how well that mistake didn't happen and how much they stand behind their work.
Hey, now he's got to catch me first.
Fair enough. Ties and boundaries. He says discussion has been had concerning adjoining properties and their value as limiters of title. This in essence is the reason for including ties in a description so as to bring lines measured on the ground into agreement with the lines of ownership on record. And there's many ways to cite ties. And he gives some examples here. So without reading it, the assumption is you guys have all read this, you know how he explains citing ties. But I am just curious how you guys cite ties. So for example, it's kind of our company practice, to go thence bearing distance to, and then qualifying cause, or along qualifying cause. So we always do our bearing and distance first, or mathematical, and then at the end of that sentence is any of those ties, calls along, calls to, qualifying to what that bearing distance represents. Where it's supposed to stop, where it's supposed to meet, where it's supposed to follow.
Now, are you talking about controlling conditions or physical ties to a corner, like bearing trees and that type of thing? Because there's two different things. The condition is something that controls the actual interpretation of the mathematics. So if you're going north 10 degrees, 14 minutes, 12 seconds along the south line, it's the south line that actually controls the direction, not the actual bearing call.
Yeah.
We're going thence bearing a distance to a point, said point 15.2 feet southeast of a 14-inch elm, that type of thing. That's an accessory call. That's a different kind of tie.
Yeah. Nope. And I guess for either one, in our methodology, right, is you have your meets and bounds description. So you would start, like you said, bearing a distance to a point, right? Said point being 15 feet northerly of this, right? But any of those qualifying ties, would be in a written method after that first mathematical meets and bounds is what I'm trying to convey.
Yeah, I guess part of the question is that when you try to put everything into a narrative, sometimes it's hard to jam all that information in there and either not screw things up to begin with or confuse the interpreter versus putting that information in there, but also having an accompanying map that's called for that is easier to depict that information on there graphically. So rather than try to jam everything into one format or the other, use both formats together, because as long as you call that map in, then anything that's on that map becomes part of the description. So you don't have to keep calling the same, the rebar, the number 5 rebar in each one if the number 5 rebar should be on the map. The problem is when those two get separated and there is no connection between the two, and then suddenly the map information is not accessible. Although there have been court cases that have said a call for an unrecorded plat is still a valid call. Try to find that unrecorded plat.
Yeah, there's certainly, if there's a call to something, there's some due diligence because there's notice given, right? That there is a map that's floating out there, and that totally makes sense. That's the hard thing, because sometimes we'll write a description and a title company gets a hold of it and rewrites it and puts it in and takes a lot of those because they just want math, right?
I just had a case settled that was the very thing that happened, Jerry, that there was an unrecorded subdivision from the 70s that was called to that gave context to every lot in there and identified which section corners controlled. And half the surveyors used the wrong section corners, so they all got the wrong location. I mean, so context, having your ties matters. Going south from a section corner means very different than going south along the section line from a section corner, or going south along the section line as depicted on such and such a map from a corner. All of that context matters.
Yeah, plus if you're starting at a section corner, you're not starting at a section corner, you're starting at a monument that represents a section corner location. And if that is an incorrect representation of that section corner, say it's 5 feet off, somebody finds better evidence later on, that doesn't mean your survey gets up and moves over 5 feet. you're still tied to that position that purported to be that section corner at the time that the survey was done. Which is why some people that say, well, if I find a section corner in the wrong place, I pull the monument. No, because that monument can have authority with respect to others. I hold in higher esteem the guys that say, well, I don't pull it, I just drive it down another 6 inches. So it's not as obvious, but at least they're kind of leaving it basically in place.
No, we just monument with multiple brass caps and stamp a date on each one. That's what we do up here.
Pin cushions, right? Yeah.
Oh, there's one, I shared this before, but there's one up in the Ogden area that's got 3 or 4 different positions now. And I think the furthest apart the two are about 100 feet. And they each have a brass cap, or at one point had a brass cap with dates stamped on it. And the records reflect the dates that each one controlled. So you can you can go back in time. Okay, this deed was written in 1967, so this is the cap that most likely controlled this one, or they'll actually call it out on the deed there, which is, it's always fun. Okay, any other discussions or thoughts on ties? This one gets tricky as Jerry and Jeremiah were kind of talking about. There is this balance and discussion of, you know, tying it to a map that graphically shows and tells a better story of what you want to convey, or getting too wordy on a description, right, where it gets confusing and muddled in like how it is. DOTs are really notorious at this because they'll give a call and then they'll say to a point which is 55 feet perpendicularly distance from this station, this, you know, approximate engineer station, this and this here, and also you get this jumble stuff, but you know, you kind of have to read between the lines to get what you want and then check it against, you know, that qualifying call of, hey, it should be perpendicularly 55 distance from this station. And there's a lot more that goes into that, but depending on how those are written can be very confusing to follow. Okay, I'm going to skip quite a bit of these ties. Didn't have much highlighted in this other than to see where our discussion went. Any other question before we jump to the next session or comments?
Nah, you're good.
Okay, good, great. I want to make sure that our younger guys, you know, have an understanding of this. That's one of the tricky ones in description. So the next section here is reference material and notice. The many references used in writing legal descriptions can be categorized generally as physical, natural or artificial, or record, public or quasi-public. Accuracy in stating facts is the most pertinent material in legal descriptions, and for this reason, one must not blindly use references, but consider them in the light of legal acceptability. This brings into the picture the matter of notice as applied to those references incorporated in description. From Black's Law Dictionary, we find it means knowledge of the existing fact or state of affairs, the means of knowledge. It further states that knowledge of facts which would naturally lead to an honest and prudent person to make inquiry constitutes notice of everything which such inquiry pursued in good faith would disclose. And that is the crux of the unrecorded plat or unrecorded survey argument, right? If it's written on a description, there is notice given, so any prudent person would then make every attempt to track that down. That's what we mentioned earlier. I do have a couple more that I just want to read out of this. Continuing, notice is either 1, statutory, made so by legislative enactment, or 2, actual, which brings to the knowledge of a fact directly home to the party, or 3, constructive. Constructive notice may be subdivided into A, where there exists actual notice of matter to which equity has been added constructive notice of facts which an inquiry after such matter would have elicited, and B, where there has been designed abstinence from inquiry for the very purpose of escaping notice. Wharton and constructive notice is information or knowledge of a fact inputted by law to a person, although he may not actually have it, because he would have discovered the fact by proper diligence, and his situation was such as to cast upon him the duty of inquiring into it. That is, the law casts on him a disability to complain unless he inquired into it. Actual notice has been defined as notice expressly and actually given and brought home to the party directly. The term actual notice, however, is generally given a wider meaning as embracing two classes, express and implied. The former includes all knowledge of a degree above that which depends upon collateral inference or which imposes upon the party the further duty of inquiry. The latter imputes knowledge. In this sense, actual notice is such notice as is positively proved to have been given to a party directly and personally, or as such he is presumed to have received personally because the evidence within his knowledge was sufficient to put him upon inquiry. And then constructive notice is a presumption of law, making it impossible for one to deny the matter concerning which notice is given, while implied notice is a presumption of fact. So notice and deeds, some of our calls, calls to other deeds. So did you guys have any questions or discussion as you read through this section, or those that have taught about, boundary law and constructive notice and implied notice, actual notice? Have anything you want to add to this section?
I just
Oh, then I
remember
had to
I
read
was
it.
served recently with actual notice of a subpoena for something I never got paid for. But man, the court still made sure I provided those documents.
Absolutely. Dave, were you going to say something?
Honestly, then I had to read it several times because I kept falling asleep during it.
That's quite the mouthful, right?
Yeah.
The simplest way I break it down for my students is constructive notice means that the evidence exists in a fashion where they can get at it because it's in a public place. Recording of a deed. You can go down and you can look up to see who's the current owner of the property according to the records. The fact that you don't do it puts the onus on you to do it. Actual notice is that you have personal knowledge of the situation, whether the stuff exists in a public depository or not. So if you drive by and see somebody else occupying the land or using the land, that's not the owner of record, then you have actual notice of someone else that might be owning it. So basically constructive is it exists in a fashion that you can get it and it's your responsibility to get it if it makes an effect on your decision. Actual is you have personal knowledge of it in some fashion.
Hey, thank you.
Am I able to say anything, not being part of the survey?
No, absolutely. Ask away or say away.
As long as it's constructive and actual.
Well, I'm hoping it is. So I had hired a surveyor to come and he did a fence survey, and that showed that the fence where it's current is not what was originally recorded. And that was printed on paper, and I took it to the city council and I gave a copy of the paper and I spoke my words and I showed the facts on the paper to the mayor and the attorney and the council and everybody else in the town that was sitting there in their chairs. And then, because as I told you before, the fence was moved, and so there was a later, that was maybe in November, and then it turned around in February where the mayor, she then just avoided anything that had to do with my bringing that survey to the attention of the city, because the survey was the city limit on my backyard. And then she accepted the other survey that another surveyor with the company had made and disregarded everything I said. So when you talk about constructive and implied and actual, and then due diligence, and I just feel like, what's going on, man? You know, they're just blowing me off. And, you know, got a lot of government and surveyors and records. And so, you know, you guys are in, this is your business, you know, but there are other people that are, like you said, somebody can do it one way and then somebody can do it somewhere else or hit the pin down 6 more inches. And I mean, where does the truth lie in all that? Because you got the book there that you're citing, but you also have all these individual circumstances and cases that arise because of maybe errors or intentions. So it's just kind of interesting to hear it, because there is all that energy that has to be put out to contest these things. You know what I mean?
That's one of the hardest parts about our job and one of the funnest parts. A great example of what you're kind of alluding to, and what I can speak to, you know, adjacent to your case, again, not being familiar, is I have over the last 2 years been working on a survey on the easterly end of our town, which is at the very base of the mountains here in Utah. And when we talk about these controlling monuments and government monuments and retracing deeds, along the base of the mountain runs a highway that recently took out all of our section corners, these government monuments that our deeds are tied to. And then as you go east up the mountains, they just never set monuments up in the mountains, thinking, you know, it's too hard to get to, they will never be used, they're not important at this time, right? So they were just never set up there, or very few of them were. And so when we go to do this survey, all of a sudden we're missing a lot of information we need. So there's a lot of survey procedures to then retrace and recreate and relocate these monuments, these theoretical positions that everything's tied to, which are then monumented physically with some sort of actual physical monument on the ground, right? So we've been working on this for a couple of years, and we last week walked the property with the landowner, and we were ready to set property corners. They had sold off a portion and they wanted to see what portion they had kept. And we start walking the property, and I just happened to be doing this when it was one of these where I could actually go out in the field that day and do it. And we set first corner, and he's like, great, that's exactly where I thought it would be. Wonderful. We walk to the next corner. Hey, that's exactly where I thought it should be. Wonderful. And we walk to the third corner, which is actually has a survey that I retraced in there. And there's a really, really old T-post. I mean, that T-post has got to be 30 years old there. And sitting right next to the T-post is a really old sprinkler head. This is all horse pasture there. The little sprinkler in there. And I'm about 3 feet off the T-post, which matched every piece of evidence I had. The survey of this adjacent parcel, you know, the deeds all matched. I mean, this was really kind of a clean, cut and dry survey. And the landowner's like, well, wait a second. That's not where I expected that corner to be. It should be at the T-post. Well, in our 2 years of walking this property and doing stuff, in everyone's mind, that T-post was there to protect the sprinkler, right? It just made sense. There was a sprinkler next to it. It was about 3 feet from this theoretical property corner, that, you know, where the deeds all matched, everything made sense. And he says to me, no, when they surveyed this property, you know, they set these T-posts as part of that survey, and this is where I've always understood it to be. Well, all of a sudden that blew 2 years of research out the water, 2 years of surveying. Like, I'm going back now and reevaluating everything because a new piece of evidence has been brought to light. So one of the hardest things for surveyors to do is we're always learning, we're always growing, we're always looking at what evidence we have, and then also interpreting that evidence. And so, you know, it's in the case of 2 surveyors disagreeing, that happens, unfortunately, probably far too often. But the reason it does, and what's really hard, is it's all about the evidence we can find at hand. And this constructive notice is is evidence of that, right? I had a survey that was old enough that we couldn't find the property corners. There wasn't a lot of evidence there, but the deeds fit. But then I was given notice of new evidence. This T-post represents the corner here, and so now I've got to reevaluate everything and see how it fits. And that's the challenge that we have to be able to resolve boundaries. Is what evidence do we have it, and then how do we interpret that? And it's always going to be the challenge in the surveying industry. Okay,
Yeah,
so
and you gotta have the money, a little bit of cash to go with it, to pay somebody as they keep doing these things, because you can't work for free. But we all know that. It's a challenge. It's okay.
and that's the other side of it too, right? Yeah, this is a job for us, and so we could talk about contract law, and we have here in other programs in the past, but that's the other challenge for the homeowner, right? Is being able to afford or pay for what that research like is to get it right and how to make those decisions. But
It's okay. I'm glad to hear what you're saying, because it's starting to make sense. I appreciate it. I'd like to learn more. You guys are good.
Thanks, Harmony. So we talked about notice, public and quasi-public records. So we've kind of touched on this a little bit. Public records are those that are at the public repositories, or our surveyors' offices, our recorders, register of deeds, call it what you will, DOTs, county roads department, stuff that is publicly accessible. And then the quasi-public records are things that maybe should have been in there or are accessible to the public, but take a little bit of digging to get to, unrecorded or unfiled surveys or plats. Many maps, the last paragraph of this is many maps exist outside the usual office of public records as defined in the recording statutes, which are helpful in their display of information or sometimes also channeled to other sources of facts. These are found in such offices as county surveyors, city engineers, county flood control, U.S. Corps of Engineers, State Division highways, railroads, power, water, gas, telephone companies, sanitation districts. These maps are classified as quasi-public. So you got to do that research. You got to dig and dig and dig until you have all the information you have, till you can feel confident in the decision you made. Okay, conveyed or described. These words were discussed in the second part of chapter 3, if any of us can remember that far back. From the standpoint of what they meant when you read them, but let us consider here the way to adapt them in creating new description. Usually in referring to a boundary deed, in the description follows the form of to the west line of that land described in deed to W.R. Brown recorded this. This means that you're tying to that west line as it is described in the deed. So this is preferable way to use such a reference. If, on the other hand, you refer to the westerly line of that land conveyed, remember that you may represent more or less than the land described, and therefore your boundary may be different than you have indicated. I've never written one that says conveyed. I can't really think of many that have said conveyed. You guys experience that a lot in your areas?
No, I haven't seen many conveyed. I think I can only think of one or two. Mostly I do the same thing. Yep. Going to the west line as described in the deed.
The only places I've used conveyed is when the boundary was ambiguous to begin with, and there might be some other element like acquiescence or adverse possession or something like that that may have fixed the line to something physical on the ground. Because at that point, the physical visible line is the marker. It's where it's the line to which the property was conveyed, even though it doesn't mathematically match the description. But that's the only reason. If it's pretty clear where the math is on the ground and lines are matching, there's no, I think described is sufficient.
Agree. I agree. Okay, this one probably gets more into our graphical representation, but reference to NAP, not a part of the survey, not a part of the parcel, not a part of the plat. I have seen that on surveys. I can't think of any plats where I've necessarily seen that. Often, like if we're splitting up a larger tract into various phases, and there just went dark on me. We'll say future development or remainder parcel or something like that, which is a similar nomenclature, is not a part. But do we see not a part very often anymore today? I was actually surprised we took the time in this chapter to kind of to talk about not a part.
See a little bit farther, nothing in I think the developed areas in your city areas, but the farther out you go, I think you'll find more than not a parts. We used to see a not a part commonly 30, 40 years ago, but now most of those have all been infilled and a lot of those are gone.
Yeah. I would assume we see it in accepting out a portion, right? Accept that portion, which is kind of the same thing, but not a part is a nomenclature is probably less heard of. Okay, multiple parcels. Some situations require a number of parcels, such as one for the fee area, several for associated easements, and perhaps one for a separate parking facility. In these instances, you have no doubt seen them in conglomerated in different ways, all under one caption. In many cases, this method is most undesirable because too often of the parcel is lifted, one of the parcels is lifted out and put in a separate document without the caption. And I've done some like this in easements and right-of-way documents. We'll write a description that says like, 2.A, which might be like a split off of a waterline T. We're doing a centerline description. And we'll come back and say beginning at point A and running thence to get, the jog off of there. That's always accompanied with a map whenever we can. But I can see the argument here if we have also including, beginning at this point and taking off the caption there that qualifies all that, how it can get split off and broken out.
Yeah, I used to do that a lot, where I'd have writing for easements, overlapping easements. I had one client that was okay with having overlapping easements on for different stuff, and it all worked for them right up until the point where I found a document where they had lifted one easement out of there, just like it says, and with no caption. And that broke me of that habit. I just started, okay, if you want to do that kind of stuff, then each one is going to be a standalone legal description.
Absolutely. Of course, I saw it the other way where I did a bunch of standalone legal descriptions. There's about 5 or 6 different open space easements, utility easements on kind of this common area that was broken up by like roads or buildings, right? And we had to write all these descriptions, and I wrote them exactly like you're saying. And we do it 2 ways. We provided a Word document of that to put in some CC&Rs, and we provided an actual kind of title blocked 8.5 by 11 easement graphic, and then 8 pages of documents. And they actually took my 9 pages of graphic, the 8 pages of easements, each individually written, and then they took the Word document behind that one, and it's just, it's a 16-page easement document now because they put every easement in twice, because some of those were supposed to be put in a CC&R, and it was, when I got the recorded easement back, I'm like, oh man, what a mess. What a mess.
You've got a license. They just work at the title company.
That's right.
I'm kidding. I appreciate my capable title company colleagues.
we've got a few really good ones here that have a good understanding of where their limits are, and Jeremiah work very closely together in the same area, and I'm sure we could name off the same 2 or 3 title agents that are really great at understanding surveying, calling us when it's outside their element. But,
Understanding that all they're doing is selling insurance and not. That's the big thing.
yeah.
There you go. Money.
I think this is probably a great place to end this chapter when we get into some more of the legalese and stuff of chapter 11, lines of title versus monuments, lines of title versus occupation. Getting into the condos and some other stuff. And we're just about at 6:30 my time. So, and we had a bunch of guys drop off. We lost Kyle and Jerry and John. And so any questions about the body, the meat of a description? Putting it all together. Okay.
Hey, can I say something?
Absolutely. Go ahead, Harmony.
Okay. So I got this guy who came out to my property and put pins in, but he never brought any kind of instruments to actually do a survey. He just used the app in his hand. And then most likely he went to the office and he wrote the description like you're talking about with the correct verbiage. And how accurate can that be when he didn't do any survey? He just put pins in according to what was in his app. Can that be a true description?
I
When he
guarantee
already-
it's wrong.
I know it's wrong, but how it is, you're right. I know it's wrong. And how am I going to come up? How am I going to contest this? Just by saying what I said to you to someone else? Or, I mean, at what point does a surveyor have to be truthful? I mean,
Hire another surveyor to see if he gets the same thing.
All right, yeah, this is a balance between the two. You can always get another surveyor to contest it and see, okay, do they come, because the law looks at this. Is it the same result any reasonable and prudent surveyor would also come up with, right? So if what he's done is in standard what any other surveyor in your area would do, then then standard practice has been followed. And without getting into it, we can't comment on that. And then the only other options is, like David said, hire another surveyor to see that, or you get into the legal side of things and attorneys and that stuff, which I won't touch any more than to say.
no, I get it. I get it. And the guy came out and I actually walked alongside of him and he didn't measure a thing. He just looked at his app until it came up with the right reading and then he put the pin in. He walked over to where he found a group of pins and then he put it in. I mean, he didn't measure anything, like those old descriptions say they took some wire and they walked 850 feet and rolled it out on the ground. Well, he didn't roll anything out. He didn't do anything but just use the GPS. And then as he was walking, his device dropped to the ground and he lost connection because the battery fell out. And then he had to reconnect.
Was he licensed?
Yeah, he's licensed and he surveyed the land behind. So he had already been paid to do a big parcel. And I was the one parcel that never hired anybody to do anything. So he just came on my land and put the pins in. I never got a bill, but he tied me in so that everything else is now the way it's going to look unless I do something, which is probably.
You got what you paid for.
I didn't even pay. That's
Exactly.
right. I got nothing because he just came on my property and did it. You're right.
Well, and I don't know exactly what he was using in terms of an instrument, but yeah, the only way you know a measurement is right is if you take it again, and then you don't know if that's right until you take it a third time. So, any
That's good.
surveyor
Thanks for
worth
telling me.
his salt is going to take measurements and compare those measurements to the record before they mark anything on the ground to represent where boundaries are.
So do you do all that in the office before you go to the field?
Generally
Set it
speaking,
up. Yeah. You'll set it
most
up
of my
in the
time's
office.
in the office before getting prepared for it.
So
A
you're
good
doing it
server,
all.
a good
Uh-huh.
server will spend the majority of his time in the office getting set up, because the most expensive people are the people who are in the field. And those are the ones you want to spend the least time in out there. So you spend most of your time in the office getting things set up, getting things prepped and ready to go. So field crew can go out and get it located and staked or whatever they have to do.
Yeah, it was a one-man crew. He did a good job. I get it.
How do you know he did a good job?
Well, he didn't do it. He, for himself, he did a good job. He was a one-man crew. He did the computer work and then he walked it. And he had his daughter put the pin in. So, and it wasn't right.
Okay,
I'll just
well
have
then,
to, I have to work on it. I'll just have to pray about it and get my, mojo and just get mean and do it. It just takes so much effort and money, but that's life. That's just life.
how valuable is your property to
There
you?
you go. It
Now,
is.
you have
And
to
I need to
be
do it. You're absolutely
you
right.
have to be the queen of your property, of your land. You have to be the protector of
That's right.
your boundary and protector of your land, because if you don't, then someone will come walk on you and will take it from you. And the only way you're going to do
And
that
that's what I have
is
to
by
do.
spending money to protect it. That's why all the
Yep, I
fences
know. You're right.
make good neighbors.
Dang, if that's not what my neighbor said 35 years ago, fences make the best neighbors.
Yes, they do.
You're right. Thank you so much. Okay, I enjoyed it. See you next week, okay?
Yep, we'll
I'll
see
be
you
here.
on the 15th, right? That's our next one.
15th, I'll be here.
Okay, we're gonna try and get 3 in this month, the 15th and the 29th. Get through
Okay,
this
thanks.
before summer. And we are, without spilling too much, we have started talking with Jeffrey Lucas about using his pincushion book next year. So let's get everything worked out for there. We'll have some great discussions next year.
Sounds good.
Thanks, everybody. Appreciate you.
All right. Thanks a lot,
Bye.
Trent.
Bye.
Bye.
Thank you.
Thank you.
Bye.